Namaskar and welcome to StudyIQ. I am your friend Rahul Saigaonkar. The agenda for today's discussion is connected with Indian polity, where we are specifically going to discuss about Article 22, especially subclause 3 and subclause 4 to 7, which deal with preventive detention rules and regulations. You'll be having a question in your mind, sir, why are we discussing this? Because in recent times, many state governments have been using the preventive detention provisions, statutes, indiscriminately. The case in point being Telangana. You do know that there is election due in Telangana very soon, and in Telangana campaign, misuse of detention law has been observed, and the Supreme Court has multiple times wrapped the Telangana government for arbitrarily using these detention provisions. Now, in light of this, let's try to understand what is preventive detention and all nitty-gritties connected with it. To get to know this information, stay with me till the very end. All right, let's begin. But before that, to all the UPSC civil services aspirants, StudyIQ's batch 2 of Prelims to interview program is about to close out in a few days. 31st October is the last date for you to enroll. Before this date, get yourself enrolled. The classes have begun, only the orientation is done, but start your journey of preparation now. Do not delay your decision making. Do not be in two minds. Select from any of the formats here, English, Hindi, or in a bilingual format according to your convenience. Select the validity. If you're preparing for 2024 exam, 25 exam, 26 examination, accordingly you can select the validities as well. Just visit our website studyiq.com and enroll soon. I'll see you in the class. All right, let's begin. Let's begin our discussion about preventive detention. Now, first thing that we need to understand is the meaning of preventive detention. There are two terms here, preventive and detention. Now, detention is quite easy to be understood. Detention basically translates to arrest. Someone detaining you or someone arresting you. When we talk about arrest or detainment, there are two kinds. One is punitive detention and another one is preventive detention. Now, punitive detention is the normal kind of arrest or detention that happens. And please remember that Article 22 of Indian Constitution, it deals with punitive detention as well as preventive detention also. The subclause 3 specifically allows for preventive detention. Article 22, subclause 1 and subclause 2, they deal with punitive detention as well. Now, what is the meaning of this punitive detention? Say, imagine I commit a crime. I commit some crime. What will happen? The police will come with a warrant that you have committed this crime and I'm arresting you, and that warrant would be from a judge or a magistrate. Appropriate magistrate judge would issue the warrant. They arrest me. Now, once they arrest me, they take into police custody and then charges are filed, etc., and I have to be produced in front of the magistrate within 24 hours. The magistrate can extend the custody, and if the police custody can be transformed into judicial custody, I may be sent to jail as well. When the charges are filed, the trial runs. When the trial runs, we go to court, etc., and then the verdict or the punishment comes. That's basically the punitive detention. That means if you commit a crime, if you do something wrong, if you do something criminal, then you are apprehended, you are taken into police custody, and you will go through the criminal justice system. That is punitive detention. Easy to understand. But there is also availability of preventive detention in Indian laws. Now, preventive detention means without even committing a crime, only in the anticipation of the crime, the police can come and arrest me, saying that if I do not arrest you, if I do not apprehend you, you are likely to commit a criminal offense. Now you're thinking, sir, is this possible? Yes, it is. Preventive detention is exactly that. The action can be taken in the anticipation of something wrong happening or in the anticipation of the crime. This is allowed according to Article 22, subclause 3, as well as Section 51 of CRPC. Section 51 of CRPC 1973, it deals with preventive detention and its grounds, right? Now, preventive detention, it does not need any warrant. A police officer or the district magistrate can issue an order and the police will come arrest me, and when they arrest me, even if they don't have a warrant, they can arrest me. There is no need for them to take me to the magistrate, etc. So this is like an extraordinary arrest in the anticipation of the crime. Of course, you do understand for preventive detention, there would be no anticipatory bail as well, isn't it? So in the anticipation of the crime, you are apprehended. Let me give an example that if you're thinking, sir, does it make sense really? Say for example, there is some sort of function, there is some sort of procession going on. and the police know that there are some antisocial elements, some gundas or some rowdies who might create some sort of disharmony, or it will be a threat to public order, then they would apprehend them under the preventive detention laws and hold them temporarily and then leave them. An idea, just an idea. Although the history of preventive detention law, it comes from the British side. British used it especially during wartime. Preventive detention laws were used against nationalists. Without any trial, they are arrested and they're put in the jail, and they're just rotting in the jail. Now you're thinking, in a democratic setup like India, what is this preventive detention law doing? It has been provided specially to maintain public order. Now question comes up, sir, who can make a law connected with preventive detention? Please remember, from MCQ perspective, preventive detention powers are both with the center as well as state. Why? Because this item is in the concurrent list. List 3, preventive detention for specific reason is mentioned. Now, under this power, the central government had brought many rules. Even now, many statutes are active. For example, the Preventive Detention Act 1950 was brought. It expired in 1969. It was repealed. Again, Preventive Detention Act. I hope you remember the famous case of A.K. Gopalan. A.K. Gopalan was arrested under the Preventive Detention Act only. Apart from that, the center has brought the MISA Act, Maintenance of Internal Security Act, which was repealed later on. COFEPOSA is still active. Conservation of Foreign Exchange and Prevention of Smuggling Act 1974, it is still active. NSA is still active. National Security Act. We also brought TADA, which has been repealed now. POTA, which has been repealed now. We have the NDPS Act, where preventive detention is available. We also have UAPA, that is Unlawful Activities Prevention Act, under which preventive detention is available. And these laws have been brought by Parliament. As I told you, central government, that is Parliament, can also bring, and the state legislatures can pass their own preventive detention laws as well. The states have used these powers. 25 states in India have preventive detention legislations, and the most exhaustive among them are Telangana law and Tamil Nadu law. The Telangana law, it is called as Telangana Prevention of Dangerous Activities Act, and those dangerous activities, they include bootlegging, dacoity, land grabbing, etc. There is a long list here. The 1986 Act, a very long name also. In short, it is called as Telangana PD Act. Apart from that, states like Tamil Nadu have brought their own preventive detention laws. Gujarat has brought its Prevention of Antisocial Activities Act, Bihar Control of Crime Act. Right? There are different acts in Maharashtra, in Uttar Pradesh. Yes, preventive detention laws are active. So states have their own preventive detention laws. Now the question is, sir, what is this preventive detention? As I told you, Article 22 of Indian Constitution, it deals with both Clause 1 and Clause 2. They deal with punitive detention. That means whenever you are arrested, there are certain protections which are available to you. If you are being arrested, say for some crime, the police shall inform you why you are being arrested. They should give you requisite rights, and reading Article 22 with the relevant sections of the CRPC, the police will come and arrest you. They have to tell you why you are arrested. Your family member should be informed. Legal counsel can be provided, etc. Apart from that, you must be presented at the nearest magistrate office within 24 hours. Now, these protections are available for punitive detention. However, in the clause 3, it clearly mentions that these rules do not apply to enemy alien. Of course, apart from that, in case of preventive detention as well. So, in India, preventive detentions are constitutional, are legal from Article 22, Clause 3. Yes, there are certain protections provided. Protection is provided means why you can be arrested under preventive detention statutes. It can be only for these reasons: for security of state, threat to the security of state. If you're a threat to maintenance of public order, the question is, what is public order? Not defined. If there is a need of maintenance of supplies and essential services and for defense, and foreign affairs or security of India, again, is a clause. Now, these are the clauses under which preventive detention can be done. And the most misused clause would be public order and this essential supplies as well, maintenance of supplies and essentials, etc. So under these two clauses, states misuse them a lot, misuse these powers a lot. Apart from this, there are certain protective clauses mentioned under Article 22 itself, especially protection under Article 22 subclause 4. It states that if anybody or any law in India, be it a union parliament law or the state law connected with preventive detention, any such law which allows for preventive detention, one cannot hold or arrest a person more than 3 months. That means 3 months is the maximum period for which a person can be detained for preventive detention or under preventive detention. If an extension is needed, such a law which allows for preventive detention, it must give you an advisory board where you will find judges of high court, and such detention can be expanded on the recommendation of the advisory board for another 3 months. Although this 3 months was reduced to 2 months by the Janata Party 1977, the Morarji Desai government had reduced it to 2 months, but it was never notified, so still it's 3 months only. Now, apart from that, there are certain other protections as well. Whoever is detained, as soon as possible, please remember, not at the time of arrest, but as soon as possible, communication regarding their arrest can be or should be provided. Apart from that, this rule protects that nothing or no disclosure of facts shall be made, or facts may not be given, especially if it is a threat. And Parliament has been given the powers to specify rules and regulations regarding that, especially a period of longer than 3 months or procedure for the advisory board, etc. The power is with the Parliament. All right. So these are some of the protective clauses for preventive detention. Now, question comes up, sir, have these preventive detentions been challenged? Yes, of course. Are they valid? Supreme Court and different high courts have interpreted. Let me give you a list of some important cases for your reference for answer writing. One of the most prominent cases is the A.K. Gopalan State of Madras case in 1950. A.K. Gopalan had challenged his detention, had challenged the Preventive Detention Act 1950 itself. And the case is one of the prominent cases where the counsel from A.K. Gopalan's side had argued that fundamental rights are not separate. Fundamental rights have to be seen together. Article 22 must be seen together with Article 21, Article 19, and Article 14. And Supreme Court disagreed with this point. The Supreme Court said that detention was justified if the procedure established by law is carried out. So the validity of preventive detention, to a large extent, it is yes, it was held valid, and in many cases the state laws have also been held valid. Although the interpretation of Article 21 has transformed, we do know from A.K. Gopalan to Maneka Gandhi case, the Article 21 has evolved slowly and steadily since 1980s. But connected to this, another very prominent case is Madhu Limai case from 1968. If I'm not wrong, the judgment came in 1970, where the judges categorically defined what is the meaning of public order. The Supreme Court held that public order is defined as harm, danger, or alarm, or a feeling of insecurity among general public. And if you're arresting someone for this, then it must satisfy this definition. And they also highlighted that public order is different from law and order. If anybody is disrupting law and order, then you cannot arrest them under preventive detention. So law and order is different, public order is different, security of state is different terms. So when you're arresting, if you're talking about public order, that must not be law and order, and this is diluted to a large extent. One of the most prominent cases for preventive detention is Haradan Saha case. Haradan Saha versus State of West Bengal, 1975. Supreme Court, in this particular case, it gave guidelines for test of preventive detention, whether it is valid or not. They gave certain rules and regulations. The preventive detention order, what is it based on? Who is the detaining authority? Has the detaining authority, district magistrate or the police, have they applied their mind, and have they understood the relevant circumstances before arresting a person for preventive detention? Power that has been exercised for achieving the purpose, does it come from a statute or not? Is there a law or not? Apart from that, who is the detaining authority? Are they acting on their own? Are they acting according to the policy, or they are taking orders from some other body? This thing also be observed. Apart from that, the satisfaction, you do understand, it simply says that the requisite satisfaction of the detaining authority, be it police or the district magistrate or the police, that requisite satisfaction, it is subjective. You do understand it is quite subjective, because preventive detention law, it gives a lot of subjectivity or a lot of discretionary powers to the detaining authority, to the person who's arresting you. Their satisfaction should be rationally based. And the Supreme Court also suggested that if they're arresting someone, then the things must be kept in mind, that what was the past conduct of that person, and it is of imperative need to detain him. It must be based on material which is stale, right? Which material which is already established. See, I told you, if they're trying to arrest a habitual offender, a gunda or a rowdy, then the requisite material should be there. All right. Apart from that, the grounds on which the order of preventive detention is made, they must be very precise, they must be pertinent, and they must also pass the degree of rationality and prudence. It should not be arbitrary and whimsical. Apart from that, the statute itself will give a timeline that from the date of arrest, 3 months possible, strict timelines should be adhered to. Now, these guidelines were given in Haradan Saha case, but they are seldom followed in letter and spirit. Now, it is because of this, so many cases connected to preventive detention, they end up with the judiciary. Apart from this, a very important case was Rekha versus State of Tamil Nadu in 2011. Now, Supreme Court was quite helpless in this case. The apex court, it agreed that preventive detention is quite repugnant. Ordinarily, in a democratic setup, we should not have preventive detention law unless and until there is an extreme emergency. They suggested that the mature democracies like USA, UK, they have preventive detention, but it can only be used during wartime. But in India, it is used quite indiscriminately. The Honorable Supreme Court agreed that under 22 clause 3, preventive detention is valid, so we do hold it valid. But Supreme Court in multiple cases has come out that if the preventive detention is arbitrary, it is whimsical, and if these guidelines are flouted, then we will give more and more emphasis on Article 21. So what is the observation of Indian judiciary is preventive detention is like a necessary evil. It is needed only to prevent public disorder. Now, when we look at the current case study, let's see how exactly is the track record of these states who have brought preventive detention laws. Telangana being the case in point. Now, Telangana has been wrapped multiple times by the Honorable Supreme Court. Now, in 2017, Telangana got a rap from Supreme Court, especially when a sari thief was preventively detained. A sari thief, right? A person who was, if I'm not wrong, his name was Ilaya, right? Ilaya is the name mentioned somewhere. I remember the case, Ilaya. He was a sari thief, and the Telangana police detained him because he was a sari thief. All right, and if we leave him, there is a possibility that he might go and basically take some saris. Okay, there would be theft of saris, etc., like that. Okay. Apart from that, recently also, as recent as 2023, September 2023, the Supreme Court has again slammed the Telangana police for using Detention Act. Now, you would not believe how Telangana has used these detention laws. There are many examples. As I told you, the PD Act of Telangana, it was amended in 2017. 13 new offenses were added, and the offenses are quite strange. See, in one of the cases, opposition MLA was preventively detained for allegedly provoking or allegedly giving a communal speech. All right. There are many other cases where people who sold spurious seeds, they were preventively detained. People who were indulged in motorcycle theft, they were also preventively detained. All right. So if you look at some of the numbers here, as per the 2021 prison statistics of the NCRB, Telangana is just behind Tamil Nadu, and ironically, the two southern states, Telangana and Tamil Nadu, they have resorted to indiscriminate use of preventive detention laws. If we look at the number, 2021 numbers, people who are detained in 2021, Telangana around 396 people, Tamil Nadu more than that, and many number of arrests have taken place. 23% arrests in Hyderabad itself, in the capital city itself. Now, if we look at some of the relevant judgments connected with Telangana itself, as I told you, Supreme Court had wrapped the Telangana government in the V. Shanta versus State of Telangana 2017 case. V. Shanta's husband was preventively detained. Why? So, in the anticipation of selling spurious seeds to farmers. Now, in this particular case, the apex court highlighted that preventive detention laws are not an alternative to normal legal process. You need to follow the normal legal process. You cannot use it as an alternative to normal criminal justice system. In 2022, in Sheikh Nazdeen versus State of Telangana, again, preventive detention was used for gold chain snatching, right? A person was indulged in gold chain snatching. He was preventively detained that if we leave him, then there would be more cases of gold snatching. And the Supreme Court suggested that preventive detention cannot be used to counter ordinary law and order situation. This was highlighted clearly that law and order is separate and public order is separate. The courts have highlighted that preventive detention powers are exceptional powers and they have to be used sparingly. But what is happening in India? More than 25 states have brought preventive detention laws and they use it indiscriminately, arbitrarily, even for petty crimes, petty thefts. And it's not just Telangana. Telangana has used it indiscriminately. Yes, Tamil Nadu has done it. Tamil Nadu uses preventive detention law quite indiscriminately. Not just Tamil Nadu. You can give example of the Madhya Pradesh government. Supreme Court had wrapped the MP government for detaining a doctor under the NSA. Preventive detention, Supreme Court has clearly suggested is a very serious invasion of personal liberty, individual's personal liberty. It had wrapped the Tripura government, Tripura police as well. So it's not just one state, but multiple states have been resorting to use of preventive detention law. The question that beckons in front of us is, in a democracy, in a modern democracy, do preventive detention laws have a place or not? Or should they have a place or not? That's the question. All right. Again, they have been held valid, but some of the suggestions that can be given here is, when a statute is made for preventive detention law, proper guidelines or a policy must be created regarding the arrest or regarding the crimes, etc., for which the arrest can be done, not like the petty crimes or petty theft, etc., for which preventive detention should be valid. All right. So some sort of a guideline, policy, or an intervention from the central government can be brought, because Article 22 subclause 7, it allows for Parliament to make rules and regulations, or I would say certain guidelines for preventive detention laws can be created. But as of now, that is the standing. They are valid, but cases reach to the judiciary, and again, it's a huge burden on the judiciary itself. All eyes will be on Telangana election, because in the election, or because of the election, the numbers of preventively detained people would go much higher. As and when an update comes, we'll have a discussion on that. But I hope from this interaction, you have gotten everything that you needed for understanding the meaning of preventive detention, rules and regulation. Please remember, preventive detention can be brought by central government or state government. It has to be a specific statute, rule, and that statute must adhere to Article 22's protection from subclause 4 to subclause 7. I do understand it's a little technical discussion, but do remember Article 22 and rules and regulations regarding preventive detention. With that note, let me end my discussion. Thank you for watching this. Jai Hind.